Hello, and welcome to Making the Rounds, a podcast by the American Medical Association featuring advice, interviews, and discussions on the most important topics impacting residents' lives and careers. In this episode, Wes Cleveland, senior attorney with the AMA, shares information on letters of intent, including the purpose of a letter of intent, what you can expect, and best practices to keep in mind. He also underscores the value of retaining an attorney when entering contract negotiations. Wes has been a practicing attorney for the past 23 years, and prior to joining the AMA, worked for the Texas Attorney General, the Texas Medical Association, and in private practice representing physicians. This episode of Making the Rounds is one in a 6-part series on navigating contract negotiations from start to finish. Here's Wes Cleveland.
One of the things that has kept showing up is this notion of a letter of intent. Okay, so what is that? Well, letter of intent is an initial letter that an employer may give you that kind of sets the expectations that are going to apply during a negotiation process. So, basically the employer will give you this letter of intent just to make sure that you are on the same page with the employer. So what does it mean to be on the same page? Well, the letter agreement, or not the, I shouldn't say the letter agreement, but the letter of intent will cover main elements of employment like how long the employment's going to be. Is it going to be for a year? The initial employment I'm talking about. Is initial employment going to be 1 year, 2 years, whatever? What's the compensation going to be? What are the benefits going to be? You know, the car, health insurance, employer paying for CME, when's the start date going to be? And also, what are your duties going to be? For example, you're going to be working full-time. What does full-time mean? What are your call responsibilities going to be? And so forth. Now, this is an important point. Hopefully everything I'm saying in this presentation is important, but this is particularly important. Usually these letters of intent aren't binding, which means just what I've said, you aren't necessarily bound by these. In other words, if the compensation would say, $300,000 and you sign it, well, that doesn't mean that you have to accept $300,000 and leave or not work there. Okay, it could possibly be later negotiated to, $350, $400, whatever it is. Okay, that's what it means to be non-binding. However, in some states and under some circumstances, it could be binding. Okay, and then you would be locked in, let's say, to that $300,000. Okay, so if you receive a letter of intent, I would recommend at that point having a lawyer even look at that. Okay, again, a lawyer who specializes in representing physicians in employment agreements. At that stage I would, because it's an important document. Now, usually what you'll also have in there is, even if it's not binding, there will be a provision in this letter of intent called a standstill agreement, which basically says, look, during the time we're talking, 60 days, whatever, during the time we're talking, all right, about you possibly working for us, you're not going to negotiate with anybody else. That's typical. Now, but here's the kind of caveat I want to bring up about the non-binding nature of letters of intent. Even if the letter of intent is non-binding, what it can do, this doesn't necessarily hamstring you. But what it can do is it can create expectations on the part of the employer, right? Let's say in terms of your compensation, that may make it more complicated for you to depart from later on in the negotiation. So, for example, let's say you receive a letter of intent and the compensation is listed again, let's just say $300,000. And you sign it, and then later you get a lawyer and you look it over and you do some research on the internet. Maybe you have access to one of the big national compensation surveys, that, for example, the Medical Group Management Association publishes those surveys. You say, no, wait a second, that's a little bit low. That's lower than the median for this geographic area and for my specialty. Well, yeah, you could go back, and you're not prohibited from going back and say, I think 400 really is more appropriate and more fair market value for my services in this part of the country. And then the employer could say, yeah, but so why are you, I thought we kind of, understood it was going to be $300,000. So it's not that it's not that you will be bound by the $300,000. That's just kind of the situation to put you in terms of expectations. So that's why I just say in this space, even when you're talking about a letter of intent, I would, at that point, try to identify a lawyer that might be able to assist you, even starting with this, with the letter of intent. Okay, now, one thing I want to also emphasize to you, and this is a matter of contract law, all right? Regardless of the conversations you may have had, promises that have been made to you during the period of discussion or negotiation, none of it's going to matter unless it's in the contract, okay? If there's promises that are made to you and it sounds great, and they don't make it into the contract, the employer's not going to be bound to that, okay? It's got to be in the contract. So that's why it's important really to review it very carefully, all right? But just keep that in mind. If it's not reduced to writing, all right, then it's not going to be part of your agreement. Now, let's talk about fringe benefits. These are important, okay? So obviously, I think probably the most questions I receive during presentations to residents is about compensation and how do I know what fair compensation is. And this is another point I want to bring up too. And I forgot to bring it up in terms of you're using a lawyer. When I get these questions about what's fair compensation for my specialty, a lot of residents will say, well, what about the MGM survey or maybe some other national survey, Sullivan-Cotter, for example? How can I get access to that information? Well, those things are pricey because they take a lot of work to develop and, several $100s to get those, probably more. I don't know. It's been a while since I've checked. But what's important to know is that, you probably won't want to spend money on those surveys, but it's very likely that the kind of attorney that you would want to engage to review your contract will have access to that survey data. So that's another thing that I want you to be aware of. Okay, now we go back to fringe benefits. So typically you'll have a litany of fringe benefits. It will include vacation, personal time off, use of a cell phone, oftentimes a company car, life insurance, license fees, credentialing application fees, and also CME. So, a lot of times, one of the bigger items is continuing medical education. Will you be given time off to go to the conferences that you think are important? And to what extent will your employer fund your attendance, your travel expenses, and the registration fees for attending those conferences? That's an important consideration often for residents. And then one thing I also want to bring to your attention is disability insurance. For some specialties, if you're physically disabled, that's it. So let's say, for example, surgery. So if you are in a specialty where if you were physically disabled for a period of time, let's say car accident or whatever, I would think very carefully in terms of getting as much disability insurance as you possibly can. That's a special note I want to make for you with that regard. Okay. One other thing I want to mention about fringe benefits also is you may be interested in having flexible time, so be sure to ask that as well. And if you are asked to work full-time, I'd make sure that in addition to knowing the location where you're going to be working and so forth, make sure that you understand how full-time is defined. Is it, depending on your specialty again, 8 to 5 Monday through Friday, or does it include weekend or evenings? Issues like that. Definitions and contracts are very important, so that's something you want to think about as well. I am a lawyer and have been representing physicians for most of my legal career. Now, I'm saying this not because I'm a lawyer. What I do recommend to you strongly is that when you receive an offer of employment, or even like I said before, the letter of intent, what you should really do is think about hiring an attorney with expertise in evaluating and negotiating physician employment agreements. And there's several reasons why I say this. There are many lawyers, many types of lawyers, that have as many different legal specialties probably as there are medical specialties. Lawyers that focus on patents, intellectual property, bankruptcy, real estate. All right? I will tell you that physician contracting issues really are kind of a world unto their own. There are requirements in those contracts because of fraud and abuse considerations that don't show up in regular commercial contracts, whether it be real estate or any other kind of contract, typical rental agreements, things like that. So it's really important for you to find a physician with expertise in these kinds of contracts. So not only can you use that kind of attorney, though, for legal advice, but there's also some practical reasons why hiring a lawyer who specializes in physician employment agreements is important. Especially for an attorney who has a lot of experience. That attorney will know the market, all right? That attorney will also oftentimes know the potential employer and the culture of that potential employer. And it may save you some time and money in negotiations. Your attorney may say, yeah, I know there's this restrictive covenant here, but I can tell you I have several clients that work for this organization, and as a matter of institutional policy, this employer simply does not negotiate its restrictive covenants, does not do much tweaking with its compensation arrangements, things like that. And that's just good information to know up front, because then you know that during negotiations, if you're receiving a no, it's not that there's gamesmanship going on, it's just simply an honest explanation of the employer's institutional policy. Also, we've talked about evaluating an employer also, like I said before, in terms of its culture. You know, if your attorney has been in that market for quite a while, that attorney will have an idea potentially of what kind of reputation that employer has in the community. It's going to depend on the size of the community, of course, but you know, your attorney might be a good resource for trying to get an idea about what the culture is like at that employer. For example, the attorney might have other clients that currently work for that employer and have worked there for many, many years, and say, you know, I have some clients there I've represented over the years. They're very satisfied with working at this employer, and it's a good place to work. And then also, when it comes in terms of paying an attorney, there's different ways that you can arrange that. You can pay them hourly. You can also say, look, you know, I've got $5,000 that I'm willing to pay. I don't want you to go over that. can you review the contract for me, maybe give me some pointers on what I might negotiate for $5,000. If you want the attorney to negotiate for you, then you might want to go, they might expect to have a little bit higher retainer. But, I think it's really important to retain an attorney with expertise in physician contracts. And I hate to wax cliche like this, but what you can think of your career so far is like you've started off on your own 1 yard line and you've driven 99 yards down and you're ready to score. You don't want to fumble the ball right at the end. You've probably, in some cases you may have a couple $100,000 in debt, maybe more. A little bit more to hire an attorney to help you perform an evaluation negotiation is going to be well worth the money. Now, one thing before I leave this issue. You may say, well, how am I going to find an attorney who specializes in this work? And it's very easy to do. Just think about what's the state in which you'd be working if you accepted the employment. Let's say it's Arizona, right? All you would need to do is call the Arizona Medical Association, talk to them, say, what physician attorneys do you know in the state that you think well of? And that medical association, who will work with these attorneys all the time, because it's a particular specialty, right, that they consult frequently on all kinds of physician issues, will know who these attorneys are and can readily recommend at least 2 or 3 for you. So that's where I would start.
That was Wes Cleveland, senior attorney on preparing a letter of intent and the value of retaining an attorney. Be sure to check out the other episodes in this 6-part series about the ins and outs of contract negotiation. For more information on how to plan for your transition to practice, visit ama-assn.org/career planning. You can also subscribe to Making the Rounds and other great AMA podcasts on iTunes and Google Play, or visit ama-assn.org/podcasts. Thanks for listening.